I caught Judge Cynthia Boyd's court the other day that had a really interesting case that I feel I need to share, mainly because I'm one that feels if I have to go to court, and am sure that I will someday, I don't recommend people to use attorneys. Most o zero of them never win cases. It's always a plea bargain which is never a bargain at all. The Bar Association's merely a fantasy. So I thought this gentleman would lose his case. He fired 2 lawyers and beat his case. So we'll share this case with you now for case law references, adding a little background music. Check it out.
And do you have any children? Age? When's the last time you saw your 2-year-old? All right. This is what the court is going to do. Court is going to sentence you to 8 years in the prison, suspended and probated for 9 years, $2,000 fine that will be probated, restitution to SAPD for laboratory testing. There's to be 200 hours of community service restitution. 100 hours will be deducted. For parenting classes, I'm going to order parenting classes. And I tell you what, this is some incentive to improve acting skills. You may be acting right now, which is great acting. If you provide proof that you were actually in the JCPenney catalog in 2023, not 22, but 2023, I'll deduct 10 hours of community service restitution, and I'll deduct the remaining 90 if you actually are in the Tyler Perry series or someone series. Not as an extra, because those are just people in the background. You understand? If you have speaking lines, I'll weigh the remaining of the hours, and that will give you incentive to work on your acting skills. All right. Here's the thing. You're going to be tested on a regular basis. I can keep you in jail for the 2 weeks for the TAP evaluation, or I can let the TAP evaluation be out of custody.
Well, I know he wants to be out of custody, and that's part of a reason we were here is to address that. But we were able to resolve this case, and so I believe that he's motivated to be released. And so, if there's other conditions,
here's the thing: your attorney is not going to be the one on probation; it's you. So we can do the TAP evaluation in custody or out of custody. But I'm telling you, if you end up testing positive for drugs while you're out of custody, they're going to bring to me a motion to revoke or tell me what's happening with you. Then you and I are going to have another conversation. And that conversation may or may not result in you doing a TAP evaluation in custody.
Out of custody.
All right. TAP evaluation out of custody, follow recommendations. There's to be 90 sober meetings in 90 days, proof of employment within 30 days, no employment as a home health care provider or with minors.
I understand. You said 90.
Sober meetings in 90 days. So every day you need to do a sober meeting for 90 days. Those are your AA meetings or NA meetings. You can either do AA meetings or NA meetings, but they're called sober support meetings now. If you go online, you can find one that is near you.
And to get a job too.
Yes. Anything else?
Yes.
Or we can go off the record. I know I sentenced you to 9 months probation. I'm sorry, 9 years probation. You're like, yay, 9 months. If you complete everything early, you can always come back and ask for early termination. You understand? All right. And this court, to be successful, you need to stay in communication with your probation officer. If you have an issue, let them know. If you feel they're not addressing it, you can always come back to court and speak to me. You understand? All right, good luck to you. They'll go over your conditions with you.
We should have condition number 2, on or about the first day of May 2025 in Bear County, Texas. The defendant, James Ross Jr., did then and there illegally use amphetamines and violently.
How do you plead to that? True or not true?
True.
Violation of condition number 2, on or about the first day of May 2025 in Bear County, Texas. The defendant, James Ross Jr., did then and there illegally use cocaine in violation of condition number 2.
How do you plead to that? True or not true?
True.
And then violation of condition number 4 in Bear County, Texas. The defendant, James Ross Jr., did then and there fail to report to the supervision officer as directed for the months of May and June 2025. Violation of condition number 4.
How do you plead to that?
not true, Your Honor, to one of them.
All right,
I
not
did not.
true to which one?
I did not.
Well, you know what?
And sentence you up to 8 years in the prison and up to $2,000 fine? Knowing that, do you still wish to plead true to violations 2 and 2?
That the court's only option.
And
No,
that,
I'm telling you what you're looking at. What you're looking at for any violation, it could be for littering. Any violation that is presented by pleading true, the court could sentence you to 8 years in the prison. Will I sentence you to 8 years in the prison? I don't know. I haven't heard anything with regards to that. But that is what you're looking at. And what I can tell you, whatever agreement you worked out with the state, if you have worked out an agreement, the court doesn't have to follow that agreement because this is a contract with the court. It's not a contract with your attorney. It's not a contract with the state. So by pleading true to 2 and 2, you are looking at a potentially 8 years in the prison and a $2,000 fine. Knowing that, do you still wish to plead true to violations of 2 and 2? That's either yes or no.
Yes.
Court will find right. Defense, what are you requesting?
well, asking for drug treatment, Your Honor. I mean, he's on probation. He tested positive for some substances. It was obviously consistent with use. We all make mistakes. We all have relapses. He was on probation for a drug offense. And he made note to me. He said, the judge told me when I pled that if I ever had problems, to contact the probation department, to let them know, to work with them. And that reflects well on me if I ever came back.
Did he do that?
Yeah.
Probation?
There would have to have moments of honor.
All right. Any objections to that witness being by Zoom at 1:30?
None.
All right. So, Ms. Abrams, if you'll let her know, we'll be back at 1:30, and if she can look through her files between now and then.
So you were smoking marijuana then?
I think we need to, just for some clarification, Your Honor, the word possession has a lay meaning and a legal meaning. And I think maybe that clarification is where the question.
No, I mean, you can
enough.
recross, or I should say redirect.
Okay, and so it's your testimony. I mean, are you disputing that Miss Dixon testified that the last time that she saw you, that she personally observed you in her office, was in April of 2025? Are you disputing that?
No.
Okay, so to be fair, you never made contact with Miss Dixon in person after April of 2025. Is that correct?
That's correct.
Okay, but it's your testimony that you had called and made contact with some different people at adult
No,
probation.
that's not my testimony.
Okay, well, explain to me. Go ahead.
I called Miss Dixon and tried to reschedule my appointment for the end of May, June. So I went in May and took a drug test to her office, but I didn't see her. So I made the payment and took the drug test.
Okay, so that's the drug test that came up positive, right? The one that was May 1st. Okay, and so you didn't report to Miss Dixon that day. You reported to the person that administered the urinalysis to you.
I actually did call her that day, and when I called her, I told her that, I'm going to come take this test. I'm running late. So can I take it on the second half of the day? And I made it right before they left. So I was the very last person in there at like 5 o'clock. So when I showed up, and they allowed me to take the test.
Okay, and then you heard Miss Dixon testify that on June 16th of 2025, you submitted a payment of $34 to probation, correct?
Right.
Okay, and you stated that that's because you wanted to stay current on your fees. Is that correct?
I wanted to show the court that I'm actually trying and I'm taking it seriously.
Okay, and so $34 was the highest amount of payment that you could make at the time?
Because I wasn't employed.
So then how do you have money to test positive for cocaine and amphetamine?
I don't have money, excuse me, to test. It was $11.
No, to buy
I didn't
controlled
buy.
substances and invest them. How did you?
I just told you that a friend came and smoked with me.
So it's your testimony that your friend came to your home and bought methamphetamine and cocaine. We all smoked it.
I didn't know about there being any cocaine, but I smoked meth then.
You smoked meth.
So it could have been in it. I wasn't aware of it because I didn't snort no cocaine.
Okay, but you didn't financially compensate this person for the narcotics, is that correct?
No,
Okay.
didn't.
You understand that as a term of your probation, you're not to hang around with people that engage in drug use and have criminal records, correct? Okay.
No, it's not my intention to be that way. I was under the stress of catching a whole aggravated robbery. That's what.
But you didn't reach out to probation and tell them, hey, I'm feeling so stressed. I'm about to use, can you please help me? You didn't do that, right?
I called him and let him know I called him. And I was worried about a case.
Did you specifically go into ingest narcotics is the question.
No, but
Okay.
I went to
Thank you.
my
And then regarding Twania Monday, you stated that's your girlfriend?
yes,
Okay, and she was with you on June 1st of 2025, correct? When you went to the alteration shop, she was with you?
and she took me. She asked her to bring me back.
Okay. We have to witness, Your Honor.
Just for some clarification, and this is an important question. You're saying on May 1st, when you went in for your drug test, you did speak to Ms. Dixon?
Yes,
Okay. And you're sure of this because you were running late that day and you ended up having to take your drug test later than usual?
right. I was supposed to take it the first half of the day because they come and they leave at 1:30 and then they come back second half until 4:30.
And if you miss your appointment or you don't reschedule, that's a violation. You understand that?
I do.
And so you weren't violated that day, were you?
I was not.
Okay, there was a lot more testimony of many violations that he went through, but right now I'm going to get right to his jury trial at this time.
It's my understanding, and we're back on the record, it's my understanding that you are asking to represent yourself. Is that correct?
That's correct.
Okay. Did you inform your attorneys that you wish to represent yourself? Okay. Now, do you understand that if you wish to represent yourself, there has to be a written voluntary waiver of the right to counsel? Did you understand?
I do.
All right. And that must be in writing and on the record. Do you understand?
I do.
Has anyone threatened you, coerced you, or promised you anything that would cause you to waive your right to have counsel?
No, but I have a question.
Yes.
So, would Mr. Porter be still sitting in my second chair with Mr. McCrae being relieved?
Mr. McCrae is not being relieved. Mr. McCrae and Mr. Porter are co-counsels on this case.
I don't want him on my case, Your Honor. He's moved arbitrarily to my best interest.
Mhm.
He's not filed a single pretrial motion,
Mhm.
which relieves me of any type of pretrial maneuvering ability.
Mhm.
I can't get a fair trial with anything he's done. He's refused to show me my discovery.
Mhm.
He's secreted evidence from me. I don't even know the case,
Mhm.
the state's case in chief about any of it at all, and it's been filed. And he's refusing to cooperate with me on these terms.
Mhm.
Continues to embellish these stories as if I'm being aggressive to him in some way, but not producing anything in lines of the things that I've asked for.
So are you saying you haven't seen a police report?
I have not.
All right. I'm going to continue to go over this. And then if you're saying you haven't seen a police report, I'm sure they'll show you that police report right now.
This report is
No.
It's-
Here's what we're going to do. We're going to answer the questions that I'm asking of you. Do you understand? All right. So back to my question. You've informed the council that you wish to represent yourself. Is that correct?
That's correct.
Now, do you understand that per the indictment, these are, of course, felony charges? Do you understand?
I do.
Do you understand if the state is able to prove up their enhancements? Well, I'm sorry, let me rephrase. For each one of these cases that are in the indictment, the state has to prove each one of those counts beyond a reasonable doubt. Do you understand?
I do.
If the state is able to prove those counts beyond a reasonable doubt, and if they are able to approve the habitual offender enhancement paragraphs, your range of punishments for counts 1, counts 2, counts 3, counts 4 are 25 years to life in prison and up to a $10,000 fine. Do you understand?
I understand.
And do you understand that if they are able to prove the enhancements, there is no eligibility for probation from a jury? Do you understand?
I do.
Have you received and reviewed a copy of the indictment?
No, I have not.
Mr. Ross, I'm going to give you a copy of your indictment.
And it says, according to Article 25.01, that the district clerk is supposed to.
Well, hand that back to me.
Thank you.
Yaya, if you will please give him a copy of his indictment.
Certified
And
copy
let
of the
me-
original.
And excuse me, and let me explain something to you. When you have attorney that is representing you,
He's not.
the attorney will receive that, and the attorney will hand it to you, and that is through the district clerk. But we'll make sure you have that today. All right. Do you understand what you're being charged with in the indictment?
Do understand it.
All right.
But,
Do you understand the elements the state must prove?
I do, and I object to the indictment.
All right. I'm sorry.
I object to the indictment.
All right. But do you understand do you understand all of the elements that the state has to prove?
I do.
Do you understand the full range of punishment with regards to each charge?
This is what you just explained to me.
My question to you is, do you understand the full range of punishment?
Let me find one.
So for the record, I'm taking that to mean that the defendant does understand. And do you understand you have a right to a jury trial? And if you choose not to have a jury trial, the state will have to agree to a waiver of a jury trial. Do you understand?
I do.
Do you understand that there will be 12 jurors that will be sitting to hear the evidence in this case? And those 12 jurors must come to a unanimous decision if they're able to. Did you understand?
I do.
Do you understand that during jury selection, there are available to you strikes and peremptory challenges?
I do. Or die.
All right. Yes. Do you understand if you're not a U.S. citizen that you will be deported, denied naturalization, and reentry? Do you understand?
I do.
All right. Then the court will allow the defendant to represent himself. And I'm sorry, after hearing all of the court's questions and answering them, do you still wish to waive your right to counsel? Do you still wish to proceed do you still wish to proceed in representing yourself?
I do.
All right. Then the court will allow you to proceed to represent yourself. There will be standby counsel. You'll need to sign the waiver. And once you sign the waiver, we will bring the jury in. We'll start with jury selection.
He needs to sign.
Oh, you're gonna send?
I'll sign when finish reading it. All right, take this off.
So this is what I'm going to explain to you. When you represent yourself, I am not allowed to tell you how to file motions. I'm not allowed to assist you, because then I become your standby counsel, and I'm neither party's standby counsel. I'm just here to hear any evidence that's presented to me, any motions that are presented to me, and make rulings. That is all.
I would like to attention and report that I am under strict abilities that I can't participate like the district attorney does. I don't have access to a computer or a copy machine or any.
Oh no, here's the thing. It's fine that motions are written, but they need to be given to the court in a specific way, and they need to be filed. Now, I am not here to tell you how to file motions. That is something that you need to know how to do, and you need to do.
You know how to do it, Your Honor. If I was to file this motion, it would come past the time that this jury has been convened, and it would cause a problem with proceedings in court. So
that's not the way the law works. What you just said.
I don't know how else I'm supposed to file a motion. It's necessary at this moment when I don't have access to any of the basic things.
I just inform you that the court accepts written motions, but as far as my telling you how to do that, that is not what I'm here for. That is for you to decide how to do that in representing yourself.
So, Your Honor, I would like to make a verbal motion. The written copy of it is right here. May I?
And Judge, we would object under the Code of Criminal
No,
Procedure.
no, just a minute. It hasn't even been filed or brought before the court yet. And that is something that needs to be done. And so, Mr. Ross, this is what I'm going to tell you again, and I want you to hear me clearly. My role is not to help you with your case. I'm just here to listen to whatever is presented to me. That's it. If I seek to help you with your case, then I'm becoming your standby counsel, and then that means I'm not being objective. So I will not do that. And what I can tell both parties is I will only consider and rule on motions that are properly brought before the court.
And I would ask for the court to have mercy and understanding with me. There are things that I'm limited to that I don't have access to at all. My hands are tied in this form of being able to.
This is what I'm going to tell you.
It's not fair.
No, this is what I'm going to tell you. And your attorneys will tell you this. My role in this case is not necessarily to have mercy and understanding. My role with regards to this jury trial is to listen to evidence, make legal rulings for motions that are presented before me, and make rulings on any objections that people may have. That is my role right here. I am not sitting. If you were found guilty, the jury would be in charge of your punishment. That's where mercy comes in. That is not with this court at this point in time. My only point is to review documents that are given to me.
Mr. McCray has been communicating with my only witness without my permission or knowledge. And
let me ask you this, and this is the only time I will ask this question. So, is it your belief that attorneys are not allowed to talk to potential witnesses? No, that's my question.
Not about understanding.
All right, so then I don't understand what you are asking of the court.
To understand an egregious crime that's taking place with obstructing justice from being served in form of interfering with my client. Well, my witness is a veiled threat and she would be arrested if she testified in my case. I need her. She is key to my defense. And he's giving her a veiled threat. And if she testifies for me, she stands a chance of being arrested.
All right, and is this something that you're saying that the witness has informed you?
Yes.
All right, that's what's called hearsay. All right. Anything else? Anything else?
Yes, I would ask that the court please move to have this man removed from my case.
That's your standby counsel.
My standby counsel is moving arbitrarily to my best interest.
That is your standby counsel. And at this point in time, your standby counsels, Mr. McCray and Mr. Porter, are just that. They are standby. They are not doing any more investigation as it relates to your case. They're just here.
Last night, Your Honor. He said a meeting with my woman this evening after court.
Yes.
If I can make a record, Your Honor, I've spoken to Tawana Monday any number of times. Tawana Monday. I've spoken to her any number of times. I would like to think we have a solid enough relationship. I even got her to bring jail clothes to the jail for you. Okay, I've spoken to her numerous times, and yes, I'm meeting with her at 5:30 today on your behalf and to talk to her about her willingness to testify because yes, according to the state's allegations, it made the argument that she was your getaway driver. So what I told her was, hey, you might want to consult a lawyer before you testify. I'm bringing her here today so that I will let her know if she needed one, she wouldn't even have to pay. This court would appoint her a lawyer to give her whatever advice and counsel that she needs. And if she got on the stand and pled the fifth, saying that she's not going to say anything because of any possible criminal liability on her part that does not reflect well on you, that's what I communicated to her.
I understand that, but before you even started communicating with her, she was full willing to be my witness.
All right, so stop. This is what I'm going to tell you. Number one, any witnesses that may or may not place themselves in a potential for criminal liability, attorneys are appointed to represent them so that attorneys can guide them on whether or not they should be testifying. And what I can tell you is, in cases, if somebody is charged, hypothetically, if somebody is charged with a criminal case and they want to call, I don't know, their co-defendant, then that co-defendant has a right to have an attorney represent them so that they can help them navigate on whether or not they want to testify and what the potential legal and criminal consequences of that will be. So here's the thing. I'm just here to hear motions. All of this side thing that you're doing, we're not here to hear that.
It's not a side thing, Your Honor. It's crucial to my defense. Okay.
All right, State.
Judge, I'm in receipt of the defendant's motion for continuance. We would object because, one, it is not timely. It is being filed on the day of trial, where the code necessitates that all pre-trial motions be filed within 7 days of trial. And further, Judge, I don't believe this is notarized, so it wouldn't be in compliance with the Code of Criminal Procedure for a motion for continuance. Because of that, we respectfully ask the court deny the motion for continuance.
I disagree with this on the grounds of have no way to get, I don't have access to a notary. I presented it to the court the best way I knew how by giving it to the district clerk to present it to the court in this time. The reason for the 3-day continuance that I don't believe would be such a burden on the court proceedings is because I have been kept completely in the dark about all the evidence to do with this case. I don't have any idea of the way or the evidence or the witnesses that the district attorney is planning on using in this case, so therefore I cannot build a reliable defense against something that I don't know that he has or not. He could just pop up with this mysterious evidence and I have no clue of it. It's not a fair trial if I don't know what he's got to go against me with so that I can build my defense against him.
All right, this case has been pending for jury trial since October 9th, 2025. It is now February 3rd, 2026. And so we are proceeding with jury trial. So we're proceeding with jury trial.
I would like to object because I have no clue of the evidence that the district attorney has against me. Mr. McCray has not made me aware of any of the pretrial motions that were filed. And furthermore, he did not produce a single pretrial motion in this case. And he would not communicate with me regarding anything to do with this case. It's just, it is not any way can be considered fair that this ground we stand on for this contest if I don't know the facts of the case.
All right, motion for continuance is denied and the defendant will be fingerprinted. Is there anything else before the jury comes out?
Nothing from the state, Judge.
All right, thank you.
I respect my elders. I protect my elders, and I was taught better than to raise my voice in my elders. And I let this situation get away from me because I felt played. I was impressed by this woman's shop. Let me get back to this thing before I run out of time. Okay, as to the crimes, as to the crimes. So for aggravated robbery, it got to be a gun. It got to be a theft. Even though the theft didn't have to take place, it had to be an attempt at a theft. None of these are the case. They made it clear that one, nothing was stolen, and just two, we heard the phone calls. We know that the defendant's entire intention was to go and collect money that was owed to him. Everybody knew it's clear that there was money owed to him. The work that he did, the money that, on top of the money that was owed to him, after the interview with the detective, she paid. She paid him this money that he went to collect. All of this for that. Had she given the defendant the money when he went to collect it, there would have been none of this. But after it's all done and said and the police are involved and lives are on the line, now you pay? as some laudable fixture of what you created. This is the result of it. Only I have to suffer. There's no theft at all. There was no assault for Daphne or Elisa, because there was no pointing the gun at them. When I was talking to them in that heated moment that was recorded by the 911 call, my phone in my hand, talking like this. Why you keep playing with me? Like, what? Didn't I work? Didn't I operate in good faith? Didn't I work for free 4 days? At the end of the second day of work, I asked for a portion of my pay. Not the entire thing, because I know she said that we aren't gonna get paid till the end of the job. I said, can I have 20 bucks? Get a little something to eat tonight and have gas money to make it back tomorrow so I can complete this job for you. That's my entire pay. So that's all it took. Another man that was there gave me $20 as testified to. But at that point, I felt like her whole intention was to get this work out of me and not pay me in the end. So I was like, if you don't give me anything, if you don't give me anything at all, I'm not coming back to work for you anymore. She took that as a threat. I took that as a sign of
5 minutes.
I took that as a sign of what could possibly be coming from this thing. I worked for you for 2 days in good faith, not getting any money, asking for a portion of my pay so that I could come back and continue working for you. And you're not even willing to give it to me, took the whole attitude, became angry with me. I'm like, you know what? You trying to get over on me. You know what? Keep it. All that you can keep it. I'll get it later or whatever. I'm not coming back up here to work for you again. And I did. I did everything I could to stay away from going back up to the shop. Only reason I went up there is because she instructed me to. That being the case, there's no theft. There was no attempted theft. There was no gun, as they testified to. But you know, are any of y'all aware of Breaking Bad? It's a series on AMC. Okay, it's a scene in Breaking Bad, and I gotta kind of hurry up and wrap it up. But this scene in Breaking Bad, this dude is in his house and he's smoking drugs. Okay, and outside of his window, he sees Jehovah's Witnesses, you know, on their bikes. Okay, they come into his house and to push the doorbell. Right, as they doing this, the drugs kick in. Boom. And when the drugs kick in, all of a sudden, this looked like biker gang pulling up on him. He's like, oh no, you know, and then, so he runs and hides in the closet and like, because it's a big biker gang outside and these little skinny dudes, Jehovah's Witnesses with their helmet on for their bikes and like, hey, so this whole inference that everyone's given that testified about me coming in here as this big bad man is doing all this hollering and screaming, demanding money is just not true. That's not the way it went. It's not the way it worked. That's not how I even operate. I had permission to be where I was at. I was in fact invited twice for the purpose of collecting monies owed. There was no intent to steal anything. There was no weapon. There was no weapon found. There's no crime here except them being mad at me because I left them to have to pay someone else to do the work that I would have done. And I guarantee you they did not do as good a job. So they gonna show me, I'm gonna show him by putting me in this position. I couldn't understand it myself, but then I found in my mind that that's the only thing it could be. When I refused to come back and work for you now, a woman's hell is no fury like a woman scorned. Now you gotta go find somebody else to try to get the quality of work that I was giving you. It's difficult. I work hard. Defense rests, Your Honor. Thank y'all.
All right, everyone, please be seated. All right, ladies and gentlemen, it's the court's understanding that you've reached a verdict in this case. Is that correct? And is that verdict unanimous in each count? All right, if you'll hand the verdict form to Deputy Laura, please. All right, if the defendant will please rise. Count 1, it states, we the jury find the defendant James Ross not guilty of the offense of aggravated robbery as charged in count 1 of the indictment. Count 1, lesser included offense of robbery. It states, we the jury find the defendant James Ross not guilty of the lesser included offense of robbery under count 1. Count 2, it states, we the jury find the defendant James Ross not guilty of the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment. Count 3 states, we the jury find the defendant James Ross not guilty of the offense of aggravated assault with a deadly weapon as charged in count 3 of the indictment. Count 4 reads, we the jury find the defendant James Ross not guilty of the offense of unlawful possession of a firearm as charged in count 4 of the indictment. Does anyone wish to have the jury polled? All right, everyone, please be seated. All right, ladies and gentlemen, the deputy will take you back to the jury room and I'll come back and speak with you briefly. Everyone, please rise for the jurors. All right, everyone, please be seated. All right, Mr. Ross, if you would like to have a conversation with your standby counsel will explain to you about expunctions. And you have 30 days to present that to the court. Is there anything else from either party before we close?
I really hope you enjoyed a learned case law from This Rest on Reactions, an inspiring clip of Judge Cynthia Boyd's courtroom. I believe she was a bit shocked herself. She's about one of the best judge and she's an equal opportunity sister. I see her moving to the Supreme Court of Justices someday, but that would certainly bore the hell out of her. Thanks for checking it out.